Hello folks, this is Abhinay Gupta from Wikipedia World. Welcome to the new lecture of Dividend, the declaration and payment of dividend. In our previous lectures, we have already discussed that the chapter of dividend basically consists of 5 sections of Companies Act 2013. Those are section 123, 124, 125, 126 and section 127. We have done with all the 5 sections, and we have also seen the revocation of dividend and other aspects too. Today we'll try and get deeper into the topic interim dividend. If you remember, we have all discussed in our lecture that dividends are basically of 3 types: proposed dividend, final dividend and interim dividend. We have discussed in brief what interim dividend is. Today we'll see the whole soul aspect of what interim dividend is. So if you go by the definition given by the Companies Act 2013, section 2 subsection 25 says dividend includes interim dividend. Yeah, that is the definition of dividend. The other aspects, that it is the return to the shareholder on their investment and stuff, that contains the meaning part of dividend. It is not the definition. So the definition is short and simple. It says that dividend includes interim dividend. We already know that interim dividend is the dividend which is paid between 2 annual general meetings. It is paid during the year. It is paid out by, it is declared by the board of directors itself. So the first thing that we understand today is the meaning. Moving on is declaration. Now, on the simple front, we know it is declared by the board of directors. But how? And from where do they pay interim dividend? How do they come to a decision that this is the point we think that shareholders should get interim dividend, the company is functioning well, the company is able to give out dividend? Now what makes them take that decision? Right? So if a board of any particular company wants to give out dividend, it needs to have profit, because as we have seen, dividend is given out of profit only, right? So the first thing is they need to have profit. But does that statement stand true in all cases? The answer is no. Although the dividend is supposed to be given out of profit, but even reserves are profit. You can give out dividend from your reserve if you want, right? So in this case, the declaration of interim dividend, the board can give out interim dividend from 2 sources. One is the surplus in the profit and loss account that has been brought forward, and second, the profit of the financial year in which the interim dividend is sought to be declared. Yes, the profit, to be precise, you'll consider the profit of the previous quarter. The quarter in which you declare the dividend, you just consider the end of the previous quarter. If you have profit in that quarter, you may move on to declare dividend out of that profit. Now, does that mean the company will declare dividend only when it profit? We already said it's no. The board of directors may decide to give out dividend in cases of losses also. But since the company is considering undergoing a loss situation, the Companies Act 2013 took forward a step to put a ceiling, to put a constraint on the powers of the board. They have decided the ceiling, the maximum limit as to what the dividend can be declared. It says that the interim dividend shall not be declared at a higher rate than the average dividend declared by the company during the immediately preceding 3 financial years. Which means, if you consider the last 3 years from the current position, from the current date of declaration, consider the immediate preceding 3 years and see what final dividends have you given in those 3 preceding years, right? And then you make an average of those 3 final dividend, and that average is the ceiling, the maximum limit up to which you can give out an interim dividend in cases of loss. Remember, if it's a profit, it's the discretion of the board to give out as much dividend as they want, considering the financial aspect of the company. But in case of loss, The Companies Act 2013 puts a constraint to their powers. Further, there is no express requirement of any specific provision in the Article of Association. Even though you haven't mentioned anything regarding interim dividend in your article, the Board of Directors still has the power to declare interim dividend. Other aspects of interim dividend remain same, like you have to deposit the amount declared into a separate bank account in a scheduled bank within 5 days, and you have to even pay out the dividend in 30 days. These are the cases similar, like they have the same limit as they stand for the final dividend. But yeah, in the time period, there's one more thing that we need to consider very specifically. When you talk about final dividend, you know that it is 30 days from the date of declaration, and the date of declaration is obviously the annual general meeting, where the shareholders declare that this is the percentage of dividend that all of you will be getting this year. They declare in front of all the shareholders. But what is the date of declaration for interim dividend? Is it the date of communication to all the shareholders by electronic mail or anything like that? No. The date of declaration for the case of interim dividend will be considered the date on which the board resolution is passed. When the board of directors they sit down and decide, this is the interim dividend we need to give out, that will be considered the date of declaration of interim dividend. So from that particular date, we'll look forward to next 30 days. It's not a month, remember. It is 30 specific dates, right? Further, the provisions for revocation of dividend remains same as in the final dividend. That dividend once declared cannot be revoked, because once it is declared, it is a debt due from the company. It is a debt due to the shareholders of the company, and you cannot revoke it. But there lies two exceptions again. One is if the dividend was declared ultra vires, and the other is if the company ceases to be a going concern. Right? Between the date of declaration and payment, if there is any unforeseen circumstance that comes up and the company ceases to be a going concern, the board of directors has the power to revoke the dividend declared. Now, what are the consequences if profits are inadequate? Right? Dividend is to be declared when the board of directors they consider that the company is going good and we are in a position to give out the money. We are in a position to give out the portion of the profit. They have to consider the adequacy of the profit. And for the same, Companies Act 2013 has laid forward one more provision which says that the board of directors will have to take the opinion of the auditors of the company, where they need to judge whether or not the profit is adequate. And in the event of absence or inadequacy of profit, the distribution shall amount to unauthorized reduction of the share capital of the company. And that may lead to penalties, tuition of penalties for the directors and the company. And the dividend so declared and paid will have to be approved, or you say it is generally approved by the shareholders at the ensuing annual general meeting that has to come up later in the year. So, we know final dividend was not supposed to be reconfirmed, or it had not to be taken any approval. But after you declare interim dividend, approval of the shareholders need to be obtained. Now let's focus on the basic difference between the interim dividend and the final dividend. To look into the matter, if we understand it, then we have three basic differences which sums up the entire thing to the entirety. Now what are those? First is that interim dividend is declared before determination of profit. If you notice, it is declared in the middle of the year, and by that time the company has not been able to determine the profit because the balance sheet has not been freezed, the P&L has not been freezed. It is still a continuance. The business of the company is ongoing, right? So interim dividend is declared before determination of profit, whereas final dividend is declared after determination of profit. Interim dividend is declared by the board of directors and final dividend is declared by the shareholders of the company. Third is that interim dividend is required to be approved by the members after declaration, and there is no such requirement in case of final dividend because members themselves declare the final dividend. So these are three basic points that we need to consider when we talk about the differences between the interim dividend and the final dividend. Interim dividend, there's no direct question asked on this topic in recent years. The last question was asked in CA final June 2009. So as per the second school of thought, this may again be important for you because it has not been asked recently, but still is an important topic. Now we know that dividend is to be declared out of profit. It may be reserves also. We'll deal about the declaration of dividend out of reserve later in the lectures. Let's see what are the consequences if the dividend is declared out of capital. Right? So what happens if the company declares a dividend out of capital? At the end, it comes down to reduce its share capital. So it is an unauthorized reduction in the capital. So obviously, if it is an unlawful deed, consequences follow. So the director, the first consequence lies on the director. The director who knowingly paid the dividend out of capital, he shall be held personally liable to make good the losses caused to the company. Whatever dividend they have given to the shareholders, that is the amount that the director will have to personally return to the company. We also have a case which is referring the Oxford Benefit Building and Investment Society, where the director was held personally liable. The second thing is that the director have a right to indemnify. They have the right of indemnity against the member. Now, not all the members. It is the fault of the director if he gives out dividend out of capital. But even if the member was aware of the fact and knowingly he has taken the dividend, knowingly he has accepted the dividend, then that is the only case when the director have the right of indemnity against them. But if the shareholder is unknown, if he is unaware of the fact, he is not liable. The consequences lie on director alone. And whether dividends improperly paid out of capital have been made good out of subsequent profit, the liability of the director ceases to exist. Right? Like in one quarter, the director declares the dividend, and since they had no profit or inadequate profit, they had to give out money out of their capital. But subsequently, when the company goes good and the company earns a good profit, and the capital is again replenished, I mean, they put the money back to the capital, then the liability of the director ceases to exist because the company again goes round and comes back to the original position. And one more important thing to remember that can be a twist, a googly in your questions in your exam is, like if the question says that the article empowers you to declare dividend out of capital or the memorandum empowers you to do so, will that be considered right? Then the answer is no, because the Act says any provision in the article or memorandum empowering a company to pay dividend out of capital shall be void. It is straight away void. Article or memorandum has no power to allow the directors to give out dividend out of capital. Right? So that is, I think, all that we'll be discussing in this chapter, in this lecture. So this is Abhinay Gupta signing off. Thank you so much.